Hey everybody, this is Charles Dobbins. Welcome to my weekly Saturday morning vlog. What I want to talk about today is an issue that has come up with several of my students just recently, in the last 3 weeks or so, where when they write the letter of intent says that if you accept this offer, let us know, and my attorney, the buyer's attorney, will get started on putting together the agreement. Now, the reason why we say that right there in the letter of intent is because we always want to remain in control of the deal. That is the number one rule. Always remain in control of the deal. And if you let the seller draft the contract, then they are controlling the deal. And if you let the realtor go out and use a standard form contract, they're controlling the deal. You want to remain in control of the deal, so you write the purchase and sale agreement yourself. So my students have my purchase and sale agreement that they have full access to. We modify it. I help them draft it and make sure it's right. And then it goes to their attorney, who will review it and make sure it complies with state law, and everybody will be happy. All right. But what's happened recently is that these students have come back and said, hey, the seller wants to use his contract. Well, first off, in our letter of intent, it clearly stated that we were going to draft the contract. So before we even do anything else, the seller's already in violation of the agreement. Not really. It's not a non-binding agreement, but it's so much for negotiating in good faith. So what happens is, what I did on this call, this coaching call, is I taught my students some of the provisions that we put into our purchase and sale agreement to protect them, so that they can see, okay, if I used Charlie's contract, here are the 10 things that I would have protections over. But if I use the seller's contract, none of those provisions are in the agreement. So therefore, I'm not in control of the deal anymore. So what I did is I went through, because most students, they don't even read this purchase and sale contract for the deals they are getting themselves into. So I go through every single paragraph and I teach you exactly what each paragraph means, how it works in reality, how it can come back and bite you. Let me go in here, and I'm going to give you a couple of examples of provisions that I include in our purchase and sale agreement, strictly to protect my students and help them get through the day. All right, so let's take a look. Here we go. I'm going to share my screen. Now, let me scroll through. I pulled out some of the highlighted parts. First off, one of the things that we do is we separate the title company and the title insurance company and the escrow agent. And my students, they are the ones who are responsible for choosing the escrow agent, because the last thing you want to have happen is to have the seller's daughter-in-law hold your money. So you want to control who the escrow agent is. Now, for many of my students, I'm their escrow agent. All right. So I hold the funds in my client funds account, and everybody's protected. And I watch that money, make sure it doesn't go anywhere where it's not supposed to. And this is from experience, guys, because I was involved in a lawsuit down in Washington, D.C., where a student had not followed my advice, and he got himself into trouble. And that earnest money that went to the seller's attorney, who happened to be a bankruptcy attorney, because the seller happened to be a bankruptcy. Ended up being a long, convoluted lawsuit. My client won, but he lost, because what he paid in legal fees was exactly the amount that was the earnest money deposit. So don't get yourself in that situation. Choose the escrow agent. Make sure you know who it is. Make sure you know who's getting that money. All right, let me see. Scroll on down here. Check this out. One of the things we put into our provisions is the seller shall be responsible for all title insurance premiums and the costs of any endorsements requested by the buyer. Ooh, that's pretty good. Now, if you can sneak this one past the seller, bravo to you, because here's what happens. Typically, the seller will pay for an owner's policy, okay? And that's it. Any endorsements are going to be paid for by the buyer, all right? Now, one of the things about title insurance is that they're typically what are called promulgated rates, which means they're all the same throughout the state, whether it's Chicago title, whether it's Stewart title. In the state of Texas, their premiums are all exactly the same. So it doesn't matter who the insurance company is, as long as it's a good, reputable insurance company. So that's why you I teach my students, and I put in the provision that they are the ones that choose the title insurance company. Because one time, one of the first deals I ever did, I had to file a title insurance claim 3 years later. Well, guess what? Title insurance company was out of business. They were bankrupt. I had to fight that one. From now on, I'm the one that owns the policy. I'm the one that is the one that was going to file the claim. I'm the one that chooses the title insurance company. Okay. Let me scroll down a couple of other things. Okay. Oh, check out this one. You're not allowed to sell, exchange, or assign, transfer, or convey, or otherwise dispose of all or any part of the project or any interest therein, or permit any of the foregoing except for personal property, which gets replaced. This type of provision is in there, especially for those people down in Texas or those mineral-rich states. Seller, you're not allowed to sell the mineral rights. Right there. That's why we have that provision in there. It's to protect you. All right, let me see. Okay, this is one here that that never appears in the letter of intent, but always appears in our contracts. And it says that if the occupancy changes by more than 5% at any time after the financing period, we get to walk. We get all of our earnest money back. Now, a wise seller will negotiate that. We'll take that provision out of there, but you put it back in and you say, listen, I got a problem. My bank requires me to have this property have a certain occupancy before I buy it. If you drop below that amount, I need to know because I'm not going to get financing. So that's why you put that provision in there. Now, 5%, that's a pretty tight number. The seller may negotiate it up to 10, 15, 20, but you want to make sure you've got something like this in there to protect yourself. Oh, here's another good one. This is one because typically what happens, let's be real. When the seller has the property under contract and he is ready to sell it and move on, he now could care less about this property, and he's not out there leasing new units. People move out. He's not trashing them out. It just becomes a fiasco, and it becomes your fiasco when you buy the property. So what we do is we say all units shall be in rent-ready condition at the time of closing unless otherwise specified herein or unless vacated within 48 hours prior to the closing. Any units vacated within 48 hours prior to the closing shall be reported to the buyer prior to the closing in sufficient time to allow final inspection. All right? Now, the way I write my inspection periods, you'll see in just a moment. Look at, follow your eyes down to this section under here under inspection. Seller agrees that buyer shall be entitled to enter upon the project to examine seller's books and records relating to seller's operations of the project and to conduct such physical inspections of the property as buyer may desire. There's no time limit on that. There's no time limit. Now, that's not the inspection period termination deadline. That's 30 days, as you'll see right here. There's 30 days right there, 30 calendar days. This paragraph defines what we can do during the inspection period. And the inspection period is from the effective date all the way to the closing date. That's the inspection period. I get to terminate in 30 days and get my money back. After that 30 days, my money is now conditionally hard. But I get to go back and look at every single unit right up until closing. And I do. Because I know that there are going to be so many units that the guy hasn't trashed out that I have to go and clean up, and I want him to pay for it. I want all my units rent ready, all right? So that's what we do. That's another thing we protect ourselves. Then we put in this property appraisal. This property appraisal, folks, if the property doesn't appraise for what the bank says, the bank's appraiser, if it doesn't comp out to what your purchase price is, after the financing period, you get to walk. You get your earnest money back right up until the day before closing. That's in there to protect you. The 80% loan to value. Well, maybe it's not 80%. Maybe all you can get is a 75% LTV. You get to walk. You get it? You're getting the feeling of this now, how this works? Let me show you some other stuff. Oh, tenant notice letters. I talked about that in the call. Remedies of default. The seller, 2 remedies of default. You can either sue the seller for specific performance, which means he's got to sell you the property, or you get all your money back. But look at what I put in my provision. It says here, buyer an amount equal to the buyer's out-of-pocket expenses incurred in connection with this transaction, including but not limited to the buyer's due diligence activities, this agreement, and buyer's loan expenses. So not only do you get your earnest money back if the seller defaults, you get the seller to pay your expenses. That's there to protect you. Let's see, what else do we have in here? Okay, memorandum of contract. Okay, what that means is it's the memorandum. When you sign a purchase and sale contract, that is an interest in land. That is a property interest. And as such, you can go down to the registry and record that document. So what it's saying here is you can record a memorandum of contract. That's the name of the document that you file down at the registry that states, hey, I got a purchase and sale contract going on that property over there. Now, what that does for the seller is it clouds his title, but it also prevents him from going out there and putting this under contract with somebody else while he's under contract with you. That's there to protect you. All right. Sellers hate that because it clouds their title. Let me see. What else do we have on there? I think I'm coming in for agreement. Total agreement. Oh, this is a good one. Listen, this is what we call in the law the merger clause. And this merger clause means that if we discussed anything outside of these four corners of this contract and it's not in this document now, it doesn't exist. So if I told you I'd give $100,000, on the closing, because you wanted to go change the bushes, and I said that to you, but it's not in this contract, it never happened. Because just remember, folks, there are two things that happen to physically happen to sellers at the closing table. They get very forgetful, and their arms become very short. So just remember that. If it's not in this agreement, it doesn't exist. That's there to protect you. Effective date and execution date, I'm not going to get too much into that. And I think that's really it. We delved in. We spoke for over an hour, talked about all the different documents that also are attached to the contract. But that's what we do. That's what the owner form is all about. And so that is what we handled. I hope this was helpful for you. Don't go it alone, folks. Don't try to do this, especially without an attorney. I mean, this is all I do. This is my business. This is what my law firm focuses on. And our whole objective is to make sure that you're protected every step of the way. If you want to find out how to work with me, you can click on my website and check out the owner form. That's my program. As I tell my students, I'm a lawyer. I'm not your lawyer. You're going to hire a lawyer. And I will work with your lawyer to make sure that you're protected and everything goes smoothly. But I can tell you right now, this is not single family. This is residential. This is multifamily. So make sure that you're protected every step of the way. So that's it, and I'll see you next Saturday. Talk to you later. Thanks.